Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
Hi everyone and a very good evening. Thank you, Amita. I think you just increased my brief a little bit by making me talk a little more. But I think I'm just going to step back and say and give my impression of why the new evidence law maybe has come about. And when I look at the provisions which are new, they and talking about civil and criminal trials, because the evidence law, as we know, is common for both. There is a definite focus or a push on the usage and recognition of evidence, as in digital evidence. So to that end, primary evidence has been expanded, as you will see, to include video recordings, to include sharing of data on multiple computer sources, to include everything. For instance, if I have sent a message over a voice note or of WhatsApp, etc., any and all of those proofs of evidence will be treated as primary evidence. That is the reading of section 57. So that is definitely changed. Point number 2, what is therefore the use and how are we equipping ourselves to use this new usage of technology? Are there enough means in place? Is there enough infrastructure in place? What does it assume? What does it warrant? What does it presume? Now I'll just pause here for a minute. If you are going to conduct a trial over video conference, we all did this candidly during the pandemic, where we didn't know that we could conduct trials through video conferencing, etc. And yes, largely arbitration, civil suits, and so on and so forth. However, and this was my personal experience talking to judges and magistrates, that the ability to conduct a trial over video conferencing frankly did not exist. If under trials, lawyers and judges in those courts at that point of time did not have the ability to do so. So while we were handling and managing civil trials and arbitration matters for our clients from the confines of our homes or offices, those under trials necessarily had to come from the prison bus into the court, and those were the only courts which I experienced were working during that time. Hopefully the new laws are equipped and are consistent, may I say, to basically facilitate under trials actually being allowed to give evidence through the prison homes. Yes, there are going to be challenges about how evidence is taken, confidentiality of that evidence, sacrosanctness of that evidence, usage of those platforms, so on and so forth. But I do think that if this is implemented in a proper way, there will be a lot of help and lot of less stress on the infrastructure. The third point I want to make is that when we talked about what Justice Patel talked about 65B, yes, we all struggled with it. I'm not saying that there was no format. We assumed there was a format, and so on and so forth. Today there is a new 63.4, and in my interpretation there are two parts to it. One, that there is requiring a hash value, and there are many other connotations and requirements for compliance. And two, there is also a second part of it which requires an expert to give that certificate. I don't know whether they are supposed to be read together, whether they are supposed to be read one in place of the other, but that is something that will be determined. And the last point I want to make is on the repeal clause, which is section 170. Now what does 170 say? All appeals, trials, etc. that have commenced after 1st July 2024 will be as per the new law. There's no difficulty in understanding that. But what happens if a suit is filed on 30th June 2024 just to test what is going to happen? Is it under the new law? Is it under the old law? Procedurally, it should be under the new law, but I'm not sure. What happens in an arbitration? Of course, strictly laws of evidence will not apply to arbitration, but hypothetically, what happens if an arbitration is invoked on 29th of June 2024? if the arbitrators decide, do they follow the procedure under the new law or the old law?